Well, thank you very much for coming, Mr. Thrall. You know procedures here as well as most people around this table, and you know that we're looking at the Parliamentary Scrutiny of Treaties, which is a bit topical, but that's not the reason we're doing it. We're doing it because it needs doing anyway. You've got some experience as a backbencher and a frontbencher in the Commons for a very long time, but also particularly as Foreign Secretary, and also in terms of the CRAG legislation. So I wondered if you could start by giving an overview of where you think we are and how effective you think that legislation was, and whether it actually fulfilled what you expected.
Yeah. Well, thank you very much, and thanks to you and all your colleagues. Are you Madam Chairman or not?
Whatever, Jack.
What do I call her? What do you call her? Lord Chairman. Thank you. Thanks very much for the opportunity to talk about this. First, on the provenance of this provision in the CRAG bill, it was entirely because I had a bee in my bonnet about the Ponsonby rules. I don't think I'd received any representation at all on this. As you remember, I'm something of a nerd. I'd taken an interest. I'd taken an interest in the history of that first Labour government in 1924, and B, in the origins of the Ponsonby rule and what the devil had happened to it. And during all the time that we were in opposition as well as in government, it struck me that it was not effective at all. So I thought that we ought to put it into legislation. It was one of those things. When I proposed it, no one could really think of a good argument against it, so it went in. There was then an issue about whether there should be an affirmative resolution procedure rather than a negative resolution procedure. And my recollection is, although this may be wrong now, because this is going back 10 years, is that I proposed that, but you will recall, Lord Chairman, that because you once headed up the Office of Darkness, Whip's office, that the last thing the Whips wanted was any more provision for affirmative resolutions. And I certainly lost that one. I can't remember at this stage how far my proposition on that got, but anyway, I lost it. But I was pleased that it had got into the Act. As to whether it's been effective, well, it's better than the alternative than there not being provision. I'd say two things. I mean, one is that, because I read through the evidence, particularly of Professor David Howarth and his colleagues, and I certainly think there is a case for there to be a scrutiny committee, which I would suggest would be a joint committee of the Commons and the Lords, properly staffed, to go through the treaties as they come through, and to determine whether there ought to be debate on the floor of each house. There would then be an issue about, well, obviously the committee would have to have a power to delay ratification, in my view, because otherwise the government could ignore what it was deciding. And I think there'd have to be debate about whether the committee could have a power to require there to be a vote. As you know, Lord Chairman, not every legislative decision has to go onto the floor these days. And again, I'm speaking from memory, but one of the things I was also keen on when I was Lord Chancellor and before was trying to improve the processing of Law Commission recommendations. And you know that has got better, and there's a special procedure there. Now there could be some treaties which are high profile, which do require a vote on the floor, and it would be for the whips to find the time. And I mean, this is a very exceptional period in terms of parliamentary time, but that for all the complaints you'll get from the whip's office is that there's no time. The truth is that an awful lot of business, certainly in the Commons, I speak less for this end, is not that important, and also the hours have been truncated. So there's no particular reason why the system that used to obtain up until the Robin Cook reforms in 2000, where affirmative resolutions were taken after the moment of interruption, could not come back. If people want to have, so I would be resistant to claims from the whip's office that they'll never find time. The other preliminary point I'd make is that, if I may suggest this to the committee, you probably already have it in hand, but I think it's really important that good data are provided about the number of treaties that are coming before the House and their content, because Professor Howarth in particular and his colleagues were making claims that both the number of treaties had increased and the nature of the subjects had changed, so they were now much more important. I don't know whether that's correct or not. I have gone through the Foreign Office action bulletins, treaty action bulletins, which they publish each month, and went through those for or a dip sample of those for 2018. I mean, I have to say that the ones I've looked at, but those monthly bulletins they're pretty prosaic treaties. I mean, so the highlight of the one for this was July was the extradition treaty with Kuwait and the accompanying treaty on mutual legal assistance with Kuwait. I mean, these are important matters, but they're not likely to stir up controversy. People just think they're a good idea and they should be approved. Thank you.
I mean, as you say, there are a whole host of treaties in varying degrees of importance and public interest. When you were actually developing CRAG, the legislation, was there much interest from other colleagues about their own, because, some of these are departmental issues rather than Foreign Office issues, even though they are treaties?
Absolutely, as I recall, absolutely none. Nor was there a huge amount of excitement in the Foreign Office about this. They just thought this was straw on a hobby horse about parliamentary scrutiny. They didn't argue with me because they weren't in a position to argue. Once you put, this is one of these things, once you put forward the proposition that Ponsonby rules should be put on a statutory basis and Parliament should have a role over ratification, which is very different from this question of negotiation or signature. What arguments can you advance on the substance? You could, if you see what I mean. I think amongst those officials in the Foreign Office who deal with day-to-day with treaties, there was a certain amount of bemusement about what was the mischief I was trying to deal with. Well, there hadn't been any scandal or anything like that, but I just thought it was wrong for the procedure not to be on the statute book.
Right. Well, Judge.
Can we just assume that when I ask this question, or the whole process from joint committee right through to possibly eventually a vote is part of the process of scrutiny? Is this process to take place when a treaty is proposed or after a treaty has been signed up to by Her Majesty's government?
After it's been signed up to.
So does that mean that if Parliament takes the view that this is unsatisfactory, it may vote it down, and then we go back and say to the other country, we're no longer bound by it?
Lord Judge, I think so, yes, because I was thinking about the sort of the practicalities of whether Parliament could have a real-time involvement in the negotiation of treaties. For any really significant treaty or convention, there is, and there's bound to be, a great deal of public and parliamentary debate anyway in advance. For example, on something like climate change. But there are plenty of other examples. mutual legal assistance when we got the idea going. They were interested in it. But when you're... sometimes there are debates in the Commons over the broad parameters of the treaty negotiations. Again, take the obvious example of climate change. But if you're negotiating a treaty, whether it's a multilateral one or a bilateral one, you're in a room, and the negotiations will have taken place over many months, but then there is a kind of final dramatic act of the negotiation. And you've got your negotiating mandate from your colleagues in government, but there will be times when you're going out of the room and getting on the telephone to say, well, I've got to have some wriggle room on this, and so on. I mean, I was, the most obvious examples there were, for example, the treaty on the constitution of the EU, where there was all sorts of horse trading going on, necessarily, in a room or outside the room, and you couldn't possibly have Parliament in continuous session to handle that. It would make life impossible.
But forgive me.
Yeah.
Ought the negotiator, the government, to know what Parliament thinks before it goes into the negotiations? Or does it just simply wait, negotiate as best the executive thinks that the treaty should be formulated, and then the executive come back to say to Parliament, this is what we've done?
I think it depends on the subject. I say if it's a big high-profile issue like climate change, then ministers will know what Parliament thinks in any event, and in all the discussions on internally, if it's that high profile, there'll be debate about what is acceptable and what isn't acceptable to ministerial colleagues and to Parliament. And you could, I think this is what I found actually unsatisfactory about the evidence which Professor Howth and colleagues came, was that they were talking in generalisations without saying, well, let's look at the last 10 years of treaties, go through the list, on which of these should there have been greater pre-signature scrutiny. Now, I've not got that list in front of me, but I've looked at the last 12 months, and none of these are particularly earth-shattering, and a lot of them are boilerplate. I think so. All of us know what's in the extradition treaty and treaty on mutual legal assistance in criminal matters. What would be the point of additional parliamentary scrutiny? I think that, in our system there is a distinction between the executive and the legislature. What in negotiating a treaty, particularly if this committee does recommend improved scrutiny at the point of ratification, and that is accepted, there will be in the minds of negotiators, when they're round the table in negotiation, that if they concede X, then the Parliament may well decide not to ratify. And that's a phenomenon.
Would the same knowledge not be in the minds of the people who are on the other side of the negotiating table? They would know that all this handshaking is all very well, but it is ultimately subject to parliamentary scrutiny and control. And why should they commit themselves in those circumstances?
Well, most systems, of which I'm aware, have some process for agreement by the Parliament or legislative body at the point of ratification. I know it's, in international law it's a sovereign act by the executive, but I can recall plenty of occasions in EU and other negotiations where somebody said to me on the other side of the table, well, I'd like to agree to that, but I've got to get this through my Parliament. And that's just in the nature of democracy. I wonder if I could just add one other, it's not quite parenthetical, but thing that struck me very forcibly as I was preparing for this. which is about the position of United Nations Security Council resolutions. Now, UN Security Council resolutions are made under a treaty, and they have the effect of treaties, often going further than that. I mean, they can be mandatory on all governments. And, for example, on sanctions and plenty else, terrorism and so on, all the post 9/11 decisions made by the Security Council. There is no process for those for signature or for ratification. I mean, once they've been determined in the Security Council, that is that. And we are one of only 5 member states who can say no at the point of decision. Everybody else just has to put up with it. Now, I'm not proposing there could possibly be a post-Security Council process of ratification before we decided whether or not we like something. And there isn't even in the US, even though they have a monist rather than dualist approach to treaty law. But I just say it's worth, I think, drawing attention to the fact that not all provisions which become international law go through the treaty process.
Bobby.
And we park that interesting issue and return to the nature of treaties. And you've recognised in what you've said that whereas there are some treaties which are not inherently very controversial, often bilateral treaties relating to various kinds of mutual recognition and cooperation, and traditionally treaties for how you resolve not to go to war with each other, how you cooperated on posts and telephones and things like that. But that there are others, and you mentioned climate change, which are of much wider significance and potential controversy. And it's not just that they're potentially controversial, they dig deeper into the lives of citizens generally and are therefore the stuff of politics. You would recognise that, wouldn't you?
Yes, of course.
Product standards, climate change, there's quite a range of these things. Is it not the case that the politics of reaching some of these treaties, and climate change is quite a good example, has now moved to the treaty-making process, and the NGOs involved and pressure groups involved now focus their attention a great deal on the treaty-making process in the hope that the process will lead to the government agreeing to something that they probably wouldn't agree in domestic legislation, which will then become policy in the UK. It may need subsequent legislation, but they will lock in policies that are rather difficult to get governments to accept.
Have you got
domestically?
Do you have an example in mind?
Well, I think in much of climate change, there might be, you might easily find examples of things which, if you had merely proposed to government that we should place this particular restriction on a fertiliser or on a form of energy generation, government might have found it very difficult to accept that. But to have it in a treaty where the government says, I'm sorry, we have to do this because we're obliged to do so, much as they've done with European legislation over the years, that's moved the politics away from Westminster to the international negotiating process. And of course, all these conferences, all the pressure groups gathered around. You've experienced that.
Yeah. Well, I think you make a very good point, Lord Beath. But I'm just trying to work. If you take climate change, which we've had policy, we've been in the vanguard on climate change, and that has been approved by Parliament, both in terms of debates and also in terms of legislation. This is an extraordinarily complicated multilateral negotiation. I had no direct involvement in this at all, but I do recall that I've now forgotten what the venue was, but at the first major negotiating conference on climate change, there was deadlock, and Lord Prescott was involved in Kyoto, thank you, in resolving that, and he did so by very skillful negotiation with a very large number of other delegates to get a deal. Now, I dare say that he had to make some concessions on behalf of the British government in order to get others to agree, because that's in the nature of these things. There's horse trading going on. And he would have to take a chance that he was going to get this through colleagues and Parliament at the end of it, because even under the old Ponsonby rules, if he'd agreed to something which was plainly unacceptable, he could have got turned over here, and ratification could have been refused. I don't think that there could be any role for Parliament in that end game. Now, I share your concern about the disproportionate power as well as influence which a lot of NGOs have, both nationally and also within the EU and internationally, because the NGOs are on the whole worthy bodies, but they are inherently undemocratic. I mean, they are voluntary bodies and enthusiasts, often but also sometimes backed by special interests as well. Certainly, if you take with climate change, there's a very clear argument for Parliament to be involved in advance in terms of the negotiating mandate, and I think actually Parliament was. In the end, you could well a conclusion of these negotiations could be that the government signs up to things which is pushing the envelope a bit. For example, on banning a fertiliser and something like that, which where it wouldn't have got that through if it was a simple standalone proposal. And then it's for Parliament to decide, looking at the outcome of the treaty negotiations in the round, well, is this worth it?
But then Parliament is in the weak position of having to use its nuclear weapon, or threaten to use its nuclear weapon, in order to achieve some modification of what's coming forward. Really what I want to follow up by asking you is, aren't we behind other parliaments, including the European Parliament, in not recognising that there's some sort of continuous process which ought to be engaged in, which allows Parliament at least to have some input at the time when, as you say, all the NGOs are having an input because they're standing outside the conference talking to everybody all the time? Oughtn't there to be some continuous process, such as the European Parliament engages in on trade treaties?
Well, I don't believe that there is a parallel between a Parliament of a unitary state, which is what we still are, and a supranational Parliament, which is what the European Parliament is. They do have scrutiny, and for sure, as negotiations are taking place. But the European Parliament, par excellence, is a Parliament which lacks real democratic accountability. Because it's so distant, there's no European polity, and is more susceptible to pressure from pressure groups and NGOs than any domestic parliament that I can think of. So I think that you will be led down a rabbit hole if you think that there's much to learn in terms of the practice of the European Parliament. It's a very different institution for very different purposes. Now, I gather from reading prior evidence that the Australians have a treaty scrutiny committee, and I'd be much more interested in how exactly that works than the European Parliament. Even were we, I'm in favour of, was in favour of us remaining in the EU, but I'm not somebody who's a fan of the European Parliament, not least because it is so unaccountable and it is so subject to unaccountable pressure from NGOs.
Lord McGregor, let's move on.
Yes. To some extent, you've already touched on the issues I want to raise with you, but can I just ask you more specifically? Has the influence and involvement of Number 10 and other government departments in the making of foreign policy changed how the government negotiates treaties?
I don't think so. I mean, the how far Number 10 is involved in foreign policy depends what the issue is. The closer you get to foreign policy being about whether we take military action, the more that Number 10 is going to be involved, and necessarily and rightly. Now, it's also been claimed that since Margaret Thatcher and then through Tony Blair, the Number 10 were determining policy and overriding the Foreign Office. I obviously didn't have any direct experience of the Thatcher administration, but my experience of the Blair administration was that was a vast oversimplification. And Prime Minister today's got many other things on his or her plate. When it came to, say, military action, post 9/11, Afghanistan and Iraq, of course Number 10, or not Number 10 actually, because they had about 3 people doing foreign policy, David Manning and 2 others. But the Prime Minister was in the driving seat of that, and absolutely right that he should be, because he is in the seat of the Commander-in-Chief of our armed forces. On other issues, contrary to the myth, I was frankly left to get on with things. And I think included, for example, the negotiations with Iran, which actually were potentially about war and peace, where the Prime Minister had confidence in what I was doing and left it to me. But there were loads and loads of other things, including detailed negotiations inside the EU, for example, on the EU Constitution and then the Lisbon Treaty, where within a broad parameter, I as Foreign Secretary and my ministers and officials were left to deal with it. So I think there's a lot of myth about this. I mean, it's worth it just bearing in mind that the Foreign Office is a lot more autonomous than it was under Lord Salisbury, who combined the role of Prime Minister with that of Foreign Secretary, and preferred the rooms in the Foreign Office to those in Downing Street for reasons which I fully understand, so ran government from there.
Can I just then come back to a point we've briefly discussed, but I want to be more specific, and that is the fact that while the UK has been a member of the EU, it has benefited from the scrutiny of proposed new international agreements carried out by the European Parliament. Does the loss of those scrutiny processes post-Brexit require Parliament to create new scrutiny mechanisms of its own? And in particular, I would like to refer to a document that the Foreign Office has submitted to us on this point, and concludes that the government stands ready to engage in discussions and consider arrangements to strengthen parliamentary scrutiny of treaties within the framework of CRAG, should there be the requisite appetite and capacity in each house. I'd just like to ask you about the requisite appetite and capacity.
Well, I think my view is that post-Brexit, obviously there will be, or there is likely to be an increase in the number of treaties which will be negotiated by the United Kingdom. Most obviously, trade treaties, were we not to be within a customs union of any kind, and over time other matters as well. I think because there is a long transitional period, it'll take time before this is noticed. As I've already made clear, Lord McGrath, I think there is a very strong case in any event for improving scrutiny. So what process should support the provisions in the CRAG Act by having, for example, a joint committee of both houses. Whether there's an appetite for that, I'm not certain. I mean, I think that, as it were, if this committee is so minded to recommend a change like this, it's then up to members here to develop the appetite of others. But I think that once colleagues at both ends start to think about the issue, which on the whole, they will say, yes, this is a good idea.
Baroness Coulson.
Mr. Straw, as I understand it, you feel that Parliament should play a more active role in the mandating phases of the treaty process, but should that also apply to the negotiating phases, as happens, for example, you just made reference to the Joint Scrutiny Committee on Treaties in the Parliament of Australia, which seems to work very well and involves civil society as well as Parliament.
It could do. Baroness Coulson, I mean, obviously, there's as I've been suggesting, not least in my answers to Lord Judge, there's a point in the negotiation where you can't keep going back to Parliament. But I think that it makes a lot of sense for there to be a better level of affirmation, of explanation and affirmation. Explanation to Parliament and affirmation by Parliament of the negotiating mandate. And that actually provides some security for the negotiators. That's a good idea. I've not looked, and no doubt all of you have, about the way exactly the Australian process works, but we are a parallel common law parliamentary country, so I would take a lot of notice of their practice and see whether we couldn't, with a few changes, adapt it here. I think it would be a good idea.
Okay, and is there any stage in the treaty process when you think that input from Parliament would strengthen the government's hand?
At the beginning, yes, as we've discussed. But I mean, by the way, although there is not a formal process at the moment to revert to what I've been saying, any sane minister and set of officials negotiating a treaty will be, and has to be, alive to whether they can get this past their colleagues. Yeah. I mean, and I'm afraid no one's going to sign up to something which would be terminal of their own career, for example. And they might do. Well, but if you're always sort of alive to this, that there's a point at which Parliament has to recognise that its role is distinct from that of the executive, and where the executive's got to be left on to get on with the process, the detailed process of negotiation, in the knowledge that whilst it can sign the outcome, the instrument, it can't ratify it without Parliament's approval.
And do you think that Parliament should have any role in the concluding observations of the United Nations when it examines us under the United Nations Charter? So there was one recently under the economic, social and cultural rights. Parliament had no role in examining the concluding observations. Should there be a better role?
I'm not. I'm afraid I'm going to have to duck that one because I'm not familiar with that process, and I'm happy to become familiar with it. But I would be making observations on the basis of lack of information.
Okay. I'll bring Lord Hunton in a minute, but Baroness Drake just wanted to follow up on this.
Staying on this issue of the balance between the prerogative of the executive and the involvement of Parliament in the mandating and negotiating phase, to what extent would a parliamentary committee on treaties be a useful forum for scrutinising the government's treaty actions? And if, in your view, it would, what powers and functions should it have?
Baroness Drake, as I've already said, I think it'd be a good idea. It should certainly have the function of looking at all treaties which have been signed and considering whether they should be ratified, and also, I mean, acting as a filter, a sifter and a filter, determining which of those should be subject to debate, and which of those should and to vote. I think that's really important. As to whether it should have a prior role, I mean, I've already indicated I think there is a case for that based on the Australian model.
You wanted to follow up on something?
May I first of all apologise for I had to be in another meeting, but I'd love to return to previous evidence you gave to this committee on the emergence of Article 50, because you were there.
I was.
Do you think it would have been a good idea for you, as in the position you held at that time, if you had perhaps thought about referring the issue back to Parliament for a view on whether there should be a right to withdraw?
Well, I think I mean, my view was that it was eccentric that the EU treaties had no provision for a country to withdraw from those treaties. I mean, and so this was a murky area where if a country did decide to withdraw from an EU treaty, it would have to fall back on the general law of treaties, and a lot of uncertainty about exactly how a denunciation would operate. So I thought it was a good idea to have that in in what became the Lisbon Treaty. I can't remember exactly where the idea came from. I think that it was out of discussions within the European Convention, the Convention on the Constitution, which was set up at the Larkin Summit in December 2001. And it had been the subject of, as I recall, of discussions, certainly between the two UK government reps on that committee, Lord Hayne and Gisela Stewart, and then famously the wording of it was developed by Lord Kerr. It could have come back to Parliament, I think, but my recollection is that I referred to this, and others did, when we were reporting on the contents of the the Constitution, and everybody thought it was a good idea, because whether you were in favour of remaining in the EU or wanted to leave, I mean, what was there to argue about, if you see what I mean?
Thank you.
Lord Norton.
From a somewhat different perspective, I mean, should devolved governments and parliaments have a role to play in treaty negotiations, especially
I think in setting, if it involves touches on the powers of a devolved administration, then in setting the mandate, then they most certainly should. As it were, as an executive point, I think they are. But I mean, let us say that post-Brexit we are determining our own agricultural policy. Well, this touches directly on the powers of the three devolved administrations. It would be preposterous, probably unlawful, but certainly preposterous, if the UK government, which necessarily is the negotiator in the room, were not to consult those administrations in advance, the executives in advance. It would be for the executives, the Scottish Government, Welsh and Northern Ireland governments, to determine themselves how far they involve their own legislative bodies.
Yes, because you're saying they should be consulted, but I mean, in the actual negotiations, do you think representatives from the devolved government should form part of the negotiating team?
Yes, I think they should. And I mean, in practice, I can. When I was Lord Chancellor, there was certainly Justice and Home Affairs negotiations within the EU where the Justice Minister from Scotland sat alongside me. I mean, I thought that was entirely right. I mean, and for the most obvious reasons. I mean, Scotland's got a different legal system, slightly different on those issues where, Wales is part of the same system as us directly, and the Northern Ireland system is a common law system with very little difference in its overall conception. But yes, is the answer.
Okay.
Lord Panic.
Yes, we've heard evidence there should be more transparency in treaty negotiation. Plainly, these negotiations involve a tension between effective diplomacy and democratic accountability. So the question is how much transparency is too much? Is there a principle that you can articulate for us?
Well, I think the principle is that all treaties on signature become public. Now, that used not to be the case, as you know. I mean, pre the First World War, there were plenty of secret treaties, because that was in the nature of sort of government in those days. And quite often, what would happen is that there'd be a public treaty between two sovereign states, and then some secret parts of these as well. Now, that no longer happens, as far as I'm aware. However, there's an issue of how far you negotiate in a goldfish bowl. And here, having read through the evidence of Lord Howth and Professor Howth and his colleagues, I thought that there was a degree of naivety there about what was called transparency. Everybody's in favour of transparency. It's, motherhood and apple pie. You can't not be. But there are a lot of negotiations which have to take place in confidence. You're literally trying to build up confidence with the party on the other side, and if what you're doing is going to be leaked, life becomes impossible. I'll give you a specific example. In 2001, from 2001 onwards, Lord Hayne and I were involved in very detailed negotiations with the government of Spain about the provisions in the 1713 Treaty of Utrecht over Gibraltar. We wanted to settle this difficult issue, trilateral issue between the government of Gibraltar, government of Spain, and ourselves about a way forward. These were really complicated negotiations, which in the end died a death. Lord Hayne and I built up good personal relationships with the government of Spain, particularly the foreign minister, Michael Josep Piqué. However, those were confidential. The Moncler, the equivalent of number 10 in Madrid, kept leaking what we were doing, and it became our life became impossible. So they would leak it for reasons. I think there was just somebody who was incontinent in that office. They would leak it, and then of course the Gibraltarians would go berserk. Now, I'm not saying that had there been proper confidentiality on these negotiations, we would have got a satisfactory result, but there was no chance of getting any decent result whilst we were negotiating in this goldfish bowl. I mean, I'll give you another example, which is outside treaties, but inside the international law, namely Security Council resolutions. In the end, the process of negotiation discussion in the Security Council is very public. Everybody can see it. But prior negotiation has to take place in private. And if I think of one of the most sort of famous resolutions, which was Resolution 1441 on Iraq, we were negotiating with potential political opponents like France and Germany and China and Russia. We only got an agreed unanimous outcome because there was confidence between the people who were negotiating, and there was privacy for this. And I can think of plenty other examples, including inside the EU. So, yes, there should be, of course, transparency about whether the government is about to enter into a negotiation, and obviously transparency about the final text. But if people want there to be international agreements, bilateral, multilateral, they have to accept that there is a point in that process where it has to take place.
Would you accept that there should be a presumption of transparency, save to the extent, which would need to be overborne, where government takes the view that confidentiality is necessary for the effective negotiations to proceed?
I'm afraid I wouldn't, no, because there would then be... first of all, I certainly wouldn't put that in legislation, because otherwise you could see that in the middle of a negotiation end up in the divisional court over some wretched argument about whether you had fulfilled the exception to the presumption. Secondly, I'm not sure what point... I don't agree with the principle. I think the principle should be no more secret treaties. Well, as far as I know, there are no more secret treaties. I mean, there are understandings. For example, the Five Eyes understanding between ourselves and the other four intelligence partners. The detail of that's not made public, but I don't think that is it may be a treaty, but I don't think it is. I mean, it's just a very clear international understanding. So transparency at the beginning of the process, transparency at the end of the process. But I think if this committee is interested in making this process better, it ought to assert that in the middle of the process, it should be for the negotiators to decide how much privacy, confidentiality there should be. And certainly not others.
But you didn't want transparency at the beginning of the discussions about Gibraltar?
Well, there was plenty of transparency there, Lord Chairman, which is we told the House of Commons that we were involved in the negotiations under the so-called Brussels process. It would have been, it would have been wrong for us not to have said this, but it would have been political suicide for Lord Hayne and myself anyway, not to try to start it. So the process, which was called the Brussels process, was public, for sure. And we set out what we were trying to achieve, which was to continue with Gibraltar being ultimately under the British Crown rather as long as the Gibraltarians wanted that. But we were trying to sort out much better the practical arrangements between Gibraltar, Kingdom of Spain and ourselves, so that you would no longer have these continuing difficulties for the life of Gibraltarians about whether they could get a phone, handmade phone calls, whether border controls were exercised and so on. It was the middle bit that we had to negotiate in public.
Finally, Lord Norton, you had a follow-up.
Yes, you know from your experience when it was with the legislative process, ministers would generally see success as Rawle has said. You got the bill through, it's on the statute book. There's a growing recognition now of the importance of post-legislative scrutiny, and not least thanks to the work of this committee. Do you think something similar could apply in the case of treaties, that you could have a parliamentary committee that part of its task was looking post-implementation at treaties? Had they achieved what they were designed to achieve? Had they become obsolete?
Yes, I think it's a good idea. And I think one of the issues I think would be for this is to decide whether that should be subject to consideration by Joint Committee on Treaties, which was dedicated to treaties, or whether in certain circumstances it would be a matter for the subject select committees. But in principle, yes.
Thank you very much indeed. We're only 1 minute over our time, so this has been a very efficient as well as an effective session.
Well, thank you very much indeed.
Thank you very much.
Thank you.